Can a child choose which parent to live with in Texas? This is one of the most common questions that I receive from parents who are going through a divorce or child custody dispute, particularly parents of older children, teenagers who might have a very strong preference regarding which parent they want to live with. And the short answer to that question is no. Children cannot choose which parent they want to live with, but they can express a preference. So let me start with sort of the overarching rule here, and that is the guiding consideration for any court, any judge, in determining which parent should have primary custody and what the possession schedule should be is the best interest of the child. The Texas Supreme Court, in a case called Hawley v. Adams, sets forth a non-exclusive list of factors for a court, a judge to consider in making child custody determinations. And one of those listed factors is the child's preference. So how does a child express his or her preferences to the court? If you're a parent, how can you ensure that your child's voice is heard? And there's two ways. One would be to file what is called a motion to confer. This is a motion that is governed by section 153.009 of the Texas Family Code. Either parent can file a motion to confer, and under that rule, under that statute, if the child is at least 12 years of age or older and you file a motion to confer, the judge has to conduct an interview of that child in chambers. The lawyers for the parents are generally not present during this interview, although I believe under the rule you can request that a transcript of the interview be made. I have never seen a lawyer make such a request in my years of practice. I think judges would frown upon a lawyer asking for a transcript or a lawyer requesting to be present during that interview, because we want to encourage the child to be candid with the judge. We don't want the child to feel pressured or influenced by the parent's attorneys. So that's why, while it might be permissible under the rule, as a matter of practice, attorneys generally don't make that request. What if the child is under 12? If you file a motion to confer for a child who is under the age of 12, then whether or not the judge interviews the child is at the judge's discretion. So if a child is under 12 and you file a motion to confer, the judge can elect not to conduct the interview. If the child is 12 years of age or older, the judge doesn't have any discretion. The judge has to conduct the interview. I have seen judges interview children under the age of 12. I think the youngest I've ever seen a judge interview a child was a 9-year-old, but that is the exception rather than rule. In general, judges do not want children to be involved in litigation, and I think they perceive those interviews as involving the children in litigation, and if they can find an excuse not to have to conduct that interview, then they're going to seize on it and not do it. I can't tell you what sort of questions judges ask in those interviews. I've heard through the grapevine, I've heard through clients that often the questions, they don't just come out and explicitly ask the child, who do you want to live with? They'll ask about their activities and their hobbies and maybe some general questions about the dynamics at home. But I suspect they get around at some point to trying to discern what the child's preference is. And sometimes the children are very motivated to express themselves. They want to tell the judge. They feel very passionately about it. It's important to remember that a child can express preferences, but those preferences are not binding on the court. The children do not have veto power. Ultimately, a judge has to decide what is in the child's best interest. Sometimes a child wants to live with a particular parent for the wrong reasons. I mentioned the best interest factors before. Other factors in addition to the child's preferences are parental fitness, or who's been the child's primary caregiver. There's a number of factors that a court can look to. The child's preferences is but one factor. I had a mediator, a retired judge who is now a mediator, tell me that he once interviewed a child in chambers who wanted to live with dad because dad was supplying him weed. There was another case where a child, this was a teenage boy, his dad was dating a stripper, and she would have her friends over to the house, and the teenage boy perhaps naturally wanted to spend more time with dad. These are not necessarily good reasons to want to live with a particular parent. Now, these are extreme examples, but you can imagine in a situation like that, a judge concluding that perhaps the child's wishes are not aligned with what is in that child's best interest. But as a general rule of thumb, assuming you're dealing with two competent, healthy parents, I think the child's preference carries weight, particularly for older children. The preference of a 15 or 16-year-old is likely going to carry more weight than the preference of a 12-year-old. So I do think with regard to teenagers that their preference carries a lot of weight, and I think it should, frankly. Is there any other way to have your child's voice heard outside of filing the motion to confer? I think the other way would be if you were to petition the court to appoint what is called a guardian ad litem. Guardian ad litem is a neutral, independent, third-party investigator who is appointed by the court to conduct an evaluation and make recommendations to the court regarding conservatorship and possession and access. It's essentially a child custody evaluation, and as part of that evaluation, the guardian ad litem is expected to interview a child that is at least 4 years of age in a developmentally appropriate manner to ascertain the child's wishes. So certainly in that situation, a guardian may factor in the child's preferences to whatever recommendations the guardian ad litem ultimately makes to the court. Now, as part of this evaluation, the guardian is talking to a lot of different people. The guardian is talking to the parents. Guardian may be talking to teachers. If the child has a therapist, the guardian will interview the therapist. Guardian will review medical records and school records. They usually conduct a home visit. They want to observe how the child interacts with the other parents. So the interview with the child is one piece of a much larger evaluation that is being conducted. And then the guardian, when he or she testifies at trial, will prepare a report and make recommendations to the court regarding which parent ought to have primary custody and what the visitation schedule should be. Again, a guardian's recommendations are just that. The recommendations are not binding on the judge, and the judge is free to disregard the recommendations by the guardian and make his or her own determination as to what is in the child's best interest. All that being said, if you do have a guardian appointed to your case, it's a nice feather in your cap if the guardian's recommendations to the court are aligned with the relief you're asking the court to grant. So, to summarize, there are two ways to have your child's voice heard in a child custody case. One would be to file the motion to confer. The second option would be to petition the court to appoint a guardian ad litem, or appoint a private forensic psychiatrist or psychologist to do a child custody evaluation, and they'll also interview the child and make recommendations to the court. So those are the two ways. The third way, I suppose this is one I haven't seen in my practice, but it would be to actually have the child testify in court. Technically, children can be competent witnesses, but I've never seen a lawyer who is brazen enough to actually attempt to bring a child to testify in a child custody case. You can imagine how that might backfire with a judge or jury to subject a child, to put a child in the middle and have to face both parents and express a preference and be subject to cross-examination, potentially hostile and aggressive cross-examination by the opposing lawyer. That would be a very searing and potentially traumatic experience for a child. And I think a judge would look disfavorably on a parent and lawyer who attempted to have their child testify as a witness. Hope you found this video helpful. As always, if you want to reach out to me and schedule a consultation, feel free to go to my website. Thank you.